under the Philippines absolute community of property section of code, I think all properties, whether acquired before or during marriage, are considered conjugal. So, Joshua, can you explain community property rules, and is there a possibility um, to vary this rule by using pre or post nuptial agreement?
Okay, thank you, Mary. So under Philippine laws, unless it is provided in a marriage settlement or a marriage agreement, the default property regime is the absolute community property regime. And when you say absolute community property, all of the properties that were uh, owned by the spouses before the marriage and at the time of the marriage and after the marriage are all owned equally by the spouses. So 50-50 share. There are, of course, exceptions as to what property will not constitute community property, and this would be property acquired during the marriage by gratuitous title by either spouse. So this would include inheritance, properties inherited by either spouse from the parents. And another exception would be property for personal use. That would also be an exception. So for the second question, yes, it is possible for the spouses to enter into a prenuptial agreement under Philippine laws. The only condition that needs to be complied with is that this prenuptial agreement must be executed, signed, and entered into by the parties before the celebration of the marriage to be effective. So if it is executed after the marriage, then it is no longer considered as valid. So this prenuptial agreement can provide whatever property regime the spouses may want. It can be a combination of community property and separation of property or conjugal partnership against. The spouses have a free hand of whatever mix they would want of their property regime. So on the last point, whether there is a possibility of a post-nuptial agreement, yes, there is a chance for spouses to have a post-nuptial agreement, so to speak. And this can be done by way of the filing of a petition before a family court for the dissolution of the community property of the spouses or whatever property regime they have chosen to govern their marriage. So this would involve court intervention, of course. So after due hearing, the court will issue a decree dissolving the whatever community property regime the spouses may have. And after that, the spouses will now have a complete separation of property regime. But do note that in this instance, both spouses must need to agree to voluntarily dissolve the property. If only one spouse would want a dissolution of the property regime, it would not work. Under this provision of law, it should be a joint effort by both of the spouses.
So just to tie this back to the succession, because in this instance, James is being shown as deceased. So what we're saying is, absent the nuptial arrangements, effectively Rosa should have 50% of the estate, and it's only the 50% held by James that is then fragmented across the heirs in the percentages. So if there's no will, then it's effectively a third share each to Arnold, Emily, and Rosa. Is that correct, Joshua?
Yes, that's correct. So upon the demise of James, automatically Rosa gets 50% of the whole estate of James. And only the 50% would be split up between the children and Rosa.
Right.
Okay. Well, so on the community property, in terms of the Philippine trading company shares, is it possible to make a community property claims against the Hong Kong trust that is holding the 30% of the trading company shares? And what about the trust shareholdings in obviously the Philippine company we spoke about? And does Hong Kong have anti-community property law protection on Philippine assets? Josh, would you like to share with us if that's something that we can look at in terms of the Hong Kong trust holding the assets?
Yes, thank you, Mary. So a potential claim may arise from Rosa as the surviving spouse on the ground that the property transferred by James to the Hong Kong trust, constituting the Hong Kong trust, is actually community property, and hence she has a 50% share in the same, including whatever income or fruits it may have realized. So the possibility, yes, there is a possibility of the community claim by Rosa. And therefore, what would be a practical advice or solution in this instance? So number one must ensure that the property used to establish the trust is either an exclusive property of that particular spouse. And therefore, meaning exclusive property, he or she has a free hand over that property. Whatever he or she wants to do with that, he is free to do so. So number two, if you're not confident, or if you know that it's not your exclusive property, then get the consent of the other spouse.
I think from the Hong Kong perspective on anti-community property laws, I think haven't seen any jurisdictions that try to block this. So if we look at the ordinary sort of trust protections in places like the Cayman Islands, BVI, Jersey, Guernsey, etc., and of course Hong Kong in this case, a community property claim is effectively matrimonial property. So it's not an inheritance-based claim. It's basically saying that that particular asset was owned jointly, and it's the courts recognizing that you can own through the sort of matrimonial domicile assets jointly in the jurisdiction. So it's a fairly old law that that these are not subject to the protections that would usually be applied on marriage breakdown and sort of the divorce courts sort of award of ancillary relief. These are separate. These are proprietary rights by virtue of the marriage being recognized. So in effect, when we create these offshore trusts and we're dealing with married couples, as you said, Josh, you need to be clear what property is being put in there and if there are any relevant consent. So I suppose when James was creating that trust, he could have got consent from Rosa to the transfer in, and she could have released any rights in that in her half share or whatever it is, if they have a nuptial agreement going forward. Is that right, Joshua?
Yes, that's correct.
And when she does that consent, are we doing that in front of notaries, or are we doing it in a court, or is it just between the parties that they do that? What's the procedure?
Well, it is best to have a written document, and a written and a notarized document as well. The reason being, a notarized document would bind third parties and not only the parties to the agreement. So it's practical for that waiver or consent to be contained in a written and notarized document.
And it's not for consideration. It's not a contract. It's just a sort of gratuitous waiver. Is that right?
Yes. Yes.
Right. And should the parties have separate legal representation when they do this?
Definitely. Yes. I would definitely advise that they have separate legal representation.
So what about the case where we already have a Hong Kong trust and we've had it for years, 10 years, let's say, and none of this was gone through when it was set up? And of course, there is a community claim in there somewhere. How do we deal with that now? So how can we, it's a delicate subject to broach anyway. I can imagine it being a fairly difficult one, right? But how do we get that waiver now? Can we do it anytime?
Well, the ideal point, Zach, would be at the point of transfer of the
Yeah,
property to the trust. So other than that, I don't imagine having another opportune time to get that waiver consent.
right.
Zach, as a trustee, if the trustee were to obtain such waiver at the prior to transfer of the assets, with Rosa having consent for James to transfer the assets to the trust, will that be something that is workable and is able to protect the assets within the Hong Kong trust?
Yeah, because the origination of this claim is going to be through the matrimonial domicile in the Philippines. And if we're following Philippine law, because that's the law that applies to the marriage, that's where it was celebrated, then that ought to be, because it will originate, if there's an attack, it will originate from the Philippines. But if it's not being recognized in the Philippines as a matrimonial right, then I think we'll be okay on a defense in Hong Kong. It's just the worrying thing is there may be a number of trusts out there that have this, where there is a community element embedded in the trust's property, and we're going to find it difficult to try and remediate that now by trying to come to some arrangement. I think that's the unfortunate bit here. But Joshua, is it possible that we just the parties just go through the procedure of waiver, even though it happened years ago, and take their chances? I mean, what can they do practically to try and solve this problem?
Yeah, in that scenario, Zach, I think what can be done would be a sort of a ratification by Rosa of the act of James transferring the property many, many years ago.
Right.
So that can also be done, I think.
Right. Okay. Very good.
Okay. Now, so coming to the US assets portion. Now, John, is it possible to make a Philippine community property claim against the US investment account, and as well as the property claim against the US land?
Yes, thanks, Mary. So the answer is yes, it is possible, but I think what the question really is getting at is how likely is it to succeed? And again, that goes back to a state-by-state analysis. Some states have more robust community property approaches to their definition of marital property. Prime example that I think is known internationally would be California. California has a very aggressive community property approach from a marital property definition. Other states, maybe in the center of the country, like say an Oklahoma or a Kansas or Nebraska, might have far less robust marital property definitions from a community property assumption perspective. So yes, it's possible. The likelihood is going to vary from state to state, and really reiterates what I raised in the first case study, that whenever you're dealing with US assets, it pays to plan ahead of time. Don't make an assumption about how your succession is going to work or the potential divorce, even under a prenup and a postnup. Don't make an assumption about how those are going to be treated. Talk to US counsel, identify which state is going to have potential jurisdiction, see if those rules in that state are amenable to a challenge, and then maybe plan around that so that you don't get an unintended consequence of what you were trying to do when distributing that property upon your passing.
Right.
And just to be clear on that, John, so you're saying that from a Philippine perspective, the US courts would respect US sort of law on land, or would they apply Philippine sort of community property rights to split it half?
Yeah, so I think our first entry threshold question is the contention issue that I raised. There's nothing in the US law that would prevent a non-contentious awarding. So they're not going to simply say, look, because the law is X in this state, we're not going to distribute it the way that a foreign jurisdiction is under succession planning. If there is a contention, though, from state to state, you're going to find a big distinction. A California piece of property is going to be treated very differently than, say, a Florida or Texas piece of property, and that court's willingness to enforce or stand up against a challenge to a foreign order of succession.
Right.